Courtrooms move quickly, yet even brief exchanges can determine a person's future. In this hearing, we observe how seemingly routine procedural steps like resets, plea negotiations, and probation rulings carry significant legal weight. Pay close attention, because the smallest legal phrases spoken here can later translate into major consequences for the defendant.
Good morning, sir. Are you Winfred Lamont? And Mr. Lamont, Mr. Fitzgerald is here on behalf of Mr. Chandler. You're charged with evading arrest or detention with previous convictions and unauthorized use of a vehicle. And Mr. Fitzgerald, what is the announcement? See that one of the cases is a little newer, but where are y'all on discovery?
I made discovery available some time ago. In fact, my notes was filed and came back in March the 13th of this year. I made discovery available and also extended an offer by email on both cases.
All right, so what I'm going to do, Mr. Fitzgerald, is I'll reset the case one more time. This will be the final reset.
Yes, sir.
So you need to get with Mr. Chandler, figure out go through all the discovery, come visit with your client, and let's have an announcement next time whether or not it's going to be working.
A final reset carries more weight than it may appear. Judges use it to indicate that further delays will not be entertained. The next time a case is called, it typically advances toward trial. For defendants, this becomes a pivotal moment where negotiations tighten and strategic decisions can directly influence the outcome of the case.
Or if it needs to go to trial, okay? Thank you.
Thank you.
Yes, sir. Are you Jose Lopez Pamias?
Yes.
And Mr. Pamias' case is set for trial to begin with jury selection next Monday. And the state has filed a motion for continuance. Mr. Coleman is a special prosecutor and specially set for sentencing part of that trial next week. Is that correct?
That's correct, Judge, in Hardin County.
Ms. Perazzo, what is your position?
Your Honor, of course, I'm going to object to the continuance. My client has been incarcerated for a very long time. This case has been reset multiple times. I understand Mr. Coleman's position, but we're ready to proceed. So
Right.
if we could get this specially set as well.
No. Well, no, it's not at that point yet.
Okay.
I am going to grant the motion for continuance. Obviously, because Mr. Pamias is in custody, I will do my best to try to get it reset as quickly as we can. Obviously, it's an older case, and he's in custody, so I'll do the best we can to get it tried as quickly as possible.
Yes, ma'am.
Yes, sir.
Thank you. You can go back with the bailiff. Good morning. Are you Kevin Harmon? And good morning, Ms. Holmes.
Good morning.
Will your client waive the formal reading of the indictment? Yes. Mr. Harmon, in cause number 24 DCCR 1612, you are charged with the second-degree felony offense of assault of a peace officer from July 9th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, sir.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules.
This is one of the most difficult moments in criminal court. The defense objects because their client remains in custody, waiting as time passes. Yet the court must weigh fairness against scheduling realities, particularly when prosecutors or essential participants are unavailable. Delays may be procedural, but for a defendant behind bars, they carry real consequences. You can hear the tension in the room as the balance between efficiency and fairness is put to the test.
Test may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. Speak up.
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Harmon is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your...
Notice how deliberately the judge moves through the plea colloquy. This is far more than mere formality. The court must confirm that the plea is voluntary, informed, and legally sound. If any step is rushed or unclear, the conviction could be challenged or even overturned on appeal. Every "do you understand" question serve a purpose. It builds a clear record that the defendant knowingly waived their rights and entered the plea without coercion, confusion, or misunderstanding.
So that the probation department can do a pre-sentence report. And that'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what's the state's position with regard to bond?
I do have one concern, Your Honor. The call where this happened was a family violence choking incident. Where he was charged, I believe, with family violence burglary with intent to commit assault. Those cases were not pursued by the complainant, so they're not pending or anything. But if he gets released, I just want some kind of safeguards in place.
Well, they didn't file the cases, and then I don't know that I can. Where are you going to live when you get out, Mr. Harmon?
I was living with some people that was just friends with.
I cannot
I
understand
was
you.
living with some people that I was just friends with,
Right?
and then wasn't. So that's why I was going back to.
But that's where all this happened?
No.
No, this is a different place. Okay. So if I let you out today, I want to, what's the name of the friends that you're saying that you're going to live with?
Iron Woods.
Say it again.
Iron Woods.
Arlie?
Iron Lee Woods.
Iron? How do you spell it?
Spell the first name.
IRAN.
Gotcha. Last name Woods?
Yes, ma'am.
Okay. So at least while this is pending, if I let you out today, I'm ordering that you live with them and not at the other place where all of this happened. Okay? Maybe later, if everything's going well and you want to have some relationship with whoever this was, I'll get more information about that in that pre-sentence report, and we can talk about it at sentencing. But what I'm going to do today, because of your plea for probation, is I'm going to reduce your bond in your case to $1,000. So if you're able to make that bond, there's a couple of things that are very important. The first thing is that if you make the bond, you go directly to the probation department so they can start that interview process for your pre-sentence report. If you don't go there and do that, then you run the risk of me not accepting this plea agreement, and things could be much worse. You understand? Also, a condition of that bond is that you are going to live with Iron Woods. No one else until either I give you permission or we discuss it again. You understand? Also, if you are arrested for anything, if you make that bond and you're arrested for anything before you come back for sentencing, obviously things could go. I don't have to accept this agreement. Okay? All right. See you.
Here is something many viewers overlook. When a judge warns a defendant that violating conditions could make the situation far worse, it is not an exaggeration. Plea agreements and probation terms are built on strict compliance. Even a single violation can trigger harsher consequences, including revocation, renewed sentencing exposure, or additional charges that place the defendant back before the court under far less favorable circumstances.
Thank you, Your Honor.
Thank you, Mr. Nichols. Good morning. Are you Katrina Swan?
Yes, ma'am.
And Ms. Swan, the best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. And Ms. Holmes, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Swan, in cause number 24, DCCR 1362, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 29th of 2024, and that was for the offense of aggravated robbery, and that was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed for the months of January, February, and March of 2025. And is that true or not true? True or not? Listen to the question. Okay, true. Count 2 alleges that you failed to never become intoxicated or under the influence of any intoxicating substance, and that you admitted to using cocaine and alcohol on January 7th of 2025. And is that true or not true? Count 3 alleges that you failed to participate in the mental health services and follow all recommendations of that. Is that true or not true? Count 5 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? Count 6 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy program. Is that true or not true?
True.
And then count 7 alleges that you're behind in your court-assessed fees. And is that true or not true? All right, did you enter your pleas of true to counts 1 through 7 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. But it's my understanding that the probation department and the state are willing to give you a chance today to go to the special needs SafeP program, which will help you hopefully get all of these issues behind you, learn how to make better decisions, stop using drugs, get the mental health treatment you need so that you can be successful on this probation. I want to make sure you understand that this is your second chance now, and you will not get a third. You are on probation for a first-degree felony. Today, right now, I could send you to prison for the rest of your life. The rest of your life, from 5 years up to 50, 60, 70, the rest of your life for violating probation on this type of offense. So you need to take advantage of everything that they teach you, because when you get out of SafeP, you'll have aftercare, you'll have people to help you, find places to live and all of that. But it's going to be up to you to take advantage of those things. Do you understand?
Yes, ma'am.
All right. I'm also going to, because you didn't report and because this is going to take some time, I'm also going to extend your probation for a period of 2 years. So you're now on a 7-year probation instead of a 5-year probation. Now, every single person who's on probation in my court and any court can get off their probations early if they do everything they're supposed to. So it doesn't have to be 7 years, but it would take you getting everything in line real quick and doing everything right. Do you understand?
Yes, ma'am.
All right, good luck to you, ma'am. You can go back with the bailiff. They're going to get some paperwork for you to sign about SafeP. You need to sign that when they get it to you. Good morning, sir. Are you Rontez Williams? And Ms. Holmes, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Williams, in cause number 22-40090, you're charged with a third-degree felony offense of fraudulent use of identifying information from January 20th of 2022. And how do you